Hey guys, attorney Marc Victor here today. I'm a criminal defense lawyer of about the last 30 years. I'm also the founder and owner of the Attorneys for Freedom law firm. And today I want to talk a little bit about these so-called stand your ground laws, also known as the Castle Doctrine. What we say here in Arizona is that you have no legal duty to retreat. That's essentially what we're talking about. I want to break it down for you and tell you why I think it really doesn't apply in most of the cases where people are sort of talking about stand your ground laws. What am I talking about here? Well, first off, think about self-defense, right? When you get to use self-defense, and you should really break this down into two different categories. Category one we'll call sort of ordinary self-defense. You can use an ordinary amount of physical force. What am I talking about here? Somebody else is an aggressor. They are threatening in an imminent type of a way to cause an ordinary physical injury. What am I thinking about? Somebody's going to punch you, push you, maybe steal some property, because you can use, in most places, ordinary self-defense, ordinary physical force, if you will, to prevent another person from causing a physical injury, even from trespassing in many cases, or for stealing property, no problem. Then there's the other category. Think deadly physical force. This almost always also includes the threat of deadly physical force. What are we talking about here? Well, either displaying a firearm or actually discharging a firearm. What do you need here? Well, different than ordinary physical force, in most cases, you can't use or threaten deadly physical force to protect property. You can never use self-defense in response to mere words alone. So I don't care how offensive somebody is being with their words. We're not talking about self-defense. Remember, sticks and stones can break your bones, but words can never hurt you. So if somebody's just saying something that's offensive, keep your hands to yourself. You're not talking about self-defense. But if somebody is threatening imminently either death or serious physical injury, and of course, what exactly constitutes serious physical injury is defined differently in different states. But you're generally thinking about broken bones, some long-time impairing type of an injury here, death or serious physical injury. Now you're in a situation where you can generally threaten or use deadly physical force. But in all of these cases where we're talking about self-defense, it all turns on what a reasonable person would believe, right? It's not what the actual person using self-defense actually believed. That's a subjective belief. That's what was in your head. But how we measure that is what a reasonable person in the same circumstances would have concluded. So if a reasonable person would have believed that using deadly physical force or threatening deadly physical force was immediately necessary to stop another person from causing death or serious physical injury, great. Then you're in a situation where deadly physical force can be used or threatened. Anything short of that, you're going to be using too much force. And remember, always in the case of self-defense, you never get to use more force than is reasonably necessary to terminate that threat, right? So if you could have got it done with a, hey, stop and push somebody, that's all you get to do. If generally just threatening, hey, I got a firearm, or showing somebody, if that's going to get the job done, go with that. It's only in the case where you have to discharge that you should actually discharge a firearm. Now, of course, don't have a lot of time to think about this analysis, because if you do have a lot of time, that means it's not imminent. So you're not in a self-defense situation. It's got to be something happening right now. The threat to do something tomorrow, that's not self-defense. Where does any of this fit with stand your ground? Stand your ground deals with whether or not there's an additional requirement, and we're talking here in terms of deadly physical force. And so in the states that do not have stand your ground, and by the way, most of them do. The vast majority of states don't have the additional requirement, which is a duty to retreat. That's how we lawyers look at the situation. Here's how the duty to retreat works in that small minority of states where you actually have a duty to retreat. The additional factor is before you can threaten or use deadly physical force, you have to also show that you couldn't retreat in complete safety. So said another way, even if you get to use deadly physical force, if you can get out of there and retreat in complete safety, and of course, complete safety, what is complete safety? If you're dealing with an imminent threat, it's sort of hard to understand how you could ever retreat in complete safety. But if you can retreat in complete safety, then you must in those small minority of states. All right, so my name is Marc Victor. Again, I'm a criminal defense lawyer with the Attorneys for Freedom law firm. You can always get a hold of me through our law firm website, which is really easy to remember, attorneysforfreedom.com. Peace.